Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hi, everybody. Welcome to Trial Talk, insights from legal expert Michael Joseph. I'm Matt Skye. Michael is a seasoned attorney with over 20 years of experience in personal injury, commercial litigation, and criminal defense. Based in Manhattan and White Plains, New York, Michael is committed to social justice and providing accessible legal representation for all. Michael, thanks for joining us.
Glad to be here.
Michael, what are some of the most common causes of construction site accidents?
There are a number of construction site accidents that aren't firm handles and have handled over and over again. Most common types of construction accidents we see are definitely falling accidents, where people are either on bad ladders, scaffolds, or don't have the proper fall protection, and they fall and get hurt as a result. So, for example, if you're on a construction site, the general contractors and landowners have the responsibility to provide safe means for you to work at elevated heights. So if they give you a ladder and the ladder is shaky or the ladder breaks, they're at fault. If you're on a scaffold and the pipe breaks or the pipe shifts or something else happens that renders the scaffold unstable and you fall, they're at fault. If you're working over an unprotected area where there's no railings and they don't give you the proper fall protection, like life vests or harnesses, a number of types of cases we've seen that people were doing bridge work or exterior work high up on New York skyscrapers. If you're working over an unprotected edge on a stairwell, for example, and you're doing an alcove work or some other kind of work that you don't have proper fall protection, they're going to be at fault. We see a lot of ladder accidents, for example, with electricians because they're constantly on ladders doing overhead work. The same thing with carpenters and who are doing trim work and other types of trades. Anybody who has to use a ladder is entitled to a safe means of work and a safe means to do the work. So if you're given a ladder or scaffold that doesn't properly support you and your materials or allow you to do the work, the general contractor and landowner are at fault for not having given you the proper equipment. Another type of accident we see a lot of are falling object cases. So for example, if you're working on a construction site and something falls and hits you in the head, be it debris or some kind of structural collapse that doesn't hold, well, the landowner and general contractor are at fault for that too. Why? Because they're required to provide hoists, buckets, nets, things to make sure, it's their job to make sure that things don't fall and hit the construction worker who's working. Another common type of accident we see with construction workers are either slip or trip or fall accidents. And New York has rules and regulations that say passageways are supposed to be kept free of debris. Because listen, if you're carrying 2x4s or rebar on your shoulder, you can't watch every step you're taking to see if there's debris or ice or something like that in the pathway. You have to focus on the load you're carrying. So New York has very strict rules about debris, ice, other things that can cause someone to slip or trip to be eliminated from walkways. So you're basically entitled to clear pathways to do your work. Another type of case we see are saw cases or circular saw cases where the guard's either been removed or the guard doesn't function well, and people get cut because of that. Under the rules and regulations, every construction worker who uses, say, a skill saw or a grinder is entitled to have a functional guard that retracts after you make the cut or after the grinding is done. That way, if the teeth come in contact with you, basically that means the guard did work. And, since doing this a while, we know what tends to happen with saw cases especially is that as you make cuts with wood, some of the syrup and gunk on the wood tends to build up inside the guard. So the good practice is at the end of the day, take the air gun and blow it out. But a lot of contractors just don't do that. And what happens is the gunk gets stuck and the guard just doesn't retract. So the guy who's doing the cut just doesn't have the protection he's required to have. Other types of injuries we see are trench accidents. For example, a lot we see trench collapses where people are digging trenches or doing excavation, and then the sides of the trench or the sides of the excavation fall back on top of them. Well, New York has bracing rules. When you do a trench below a certain height, I should say, you're required the trench itself is required to be shored and braced. So to prevent that type of cave-in from happening. Another type of accident we see a lot of is demolition accidents, where people who are hurt by either falling walls or pieces of walls or debris from demolition walls that are being demolished, fall and hit people. Well, New York laws has very strict rules on the progress of demolition, securing of walls that are being demolished so they don't fall onto people, and a lot of other rules. So in general, if you're on a construction site and you got hurt, there's probably some rule or regulation that was meant to protect you that wasn't followed. And if you were hired on a construction site because the general contractor or the landowner didn't follow the rules, you have a lawsuit. And not only that, the general contractor and landowners are responsible to provide these safety devices and ensure these safe practices. So even if it was your own, one of the most common questions are city construction accident lawyers are asked is, well, can I sue even if my boss gave me the bad ladder? Or can I sue even if my boss gave me the bad saw? Well, the answer is yes, because the general contractors, it's their responsibility to make sure you have good equipment, even if it was your boss who gave you the equipment. Since the general contractor failed to provide safe equipment, they're at fault under the law.
So you detailed for us a lot of worker protections that are out there. Can you explain a little more of the ladder law? What is that exactly?
The ladder law is a nickname that was given to Labor Law 240, and basically it protects any workers who have to work at an elevation. So any worker that has to work generally above 4 feet is required to have a safe means to get them to the elevation and to keep them safe while they're at an elevation to protect them from the effects of gravity. So what does that mean? That means you need to have the right ladder in good repair, and the right ladder for the job. So for example, if you're given a 6-foot ladder and you have to work 9 feet in the air and you can't do it without stepping on the top step, that's not a good ladder. If the ladder is a leaning ladder, they're required to have someone to hold the ladder so it doesn't shift. If you're on a ladder and it shifts because no one was holding it while you're working, that's a violation of the ladder law. So the ladder law, Labor Law 240, applies to both ladders and applies to scaffolds, and it requires that the ladder be suitable for the work that's being done and to support the worker and the materials.
If ladder breaks while in use, can the worker sue? Who do they sue?
If you're a worker on a construction site and you're using a ladder that breaks while you're doing your work and you're on a ladder, the general contractor and landowner are responsible for that and can be sued under Labor Law 240. Why? Because Labor Law 240, also known as the ladder law, places non-delegable duties on the general contractor and landowner of a construction site. What does non-delegable mean? It means you can't say, no, I told someone else to do this, or it was someone else's job. It's non-delegable. It's the general contractor and landowner's responsibility to make sure that everyone working on the site, including some contractors' employees, have safe means to do their work. They have safe ladders, they have safe scaffolds, and they have other devices to protect them from falls. So if they have to work at a certain elevation, close to edges, or they have to climb up, for example, bracing, they have to have tie-ins so that they can coax the harnesses in. So while they're climbing, they don't fall to the bottom of the floor. So if you're asked to climb up, for example, bracing to get to the top deck and you're doing work and you don't have a lifeline, a harness, or if you have a lifeline and a harness and there aren't tie-in points so that you can click in to various points on the scaffold to break your fall in case you do slip, that's a violation of Labor Law 240. Also, what you see sometimes in New York, we have bad winters. Sometimes there's ice on the sites that aren't protected, and workers are expected to climb up bracing that's icy. Well, that's also a violation of the labor law because that icy joint or an icy scaffold, which could be slippery, isn't a safe device. Likewise, if you're on a ladder and there's no safe place to put the ladder because the site is covered with ice, well, you can't properly place that ladder to do the work. That's also a violation of Labor Law 240. So there's a number of factual scenarios where if you're injured because you have an unsafe ladder or you couldn't use a ladder in a safe way, or you had the wrong ladder and were expected to do the job, Labor Law 240 is violated. We've had a number of cases where, if you can believe it, we've had painters who have to paint the exterior of buildings. They're not given long enough ladders, so they actually tie or tape the ladders together, and that's how they're expected to get up. And naturally what happens is at some point where the fracture point is, so to speak, the ladder is going to either fall apart where it's tied, or if the tying is so strong that it holds it together, there might be another weak point on the ladder itself when the ladder just bends and people fall, sometimes several stories. So these are the types of accidents that Labor Law 240 was intended to prevent.
So in a more general sense, when can an injured construction worker sue for an on-the-job injury, and when can they not sue?
If a construction worker is injured in New York on a job site, they can sue if there's been a violation of the labor law. And really, there's so many different rules and regulations that are intended to provide safety. They cover everything from, safe platforms to elevation-related risks to excavations to machine operation to demolition. There's just so many different regulations to pile driving. You name it, there's probably a regulation on it. The only time that you really can't sue for a labor law violation is if you're injured because of something that no one was at fault for. For example, if you're picking up a load and your back goes, or in some cases, there are some limited cases where the labor law doesn't apply. For example, work being done on 1 or 2 family homes that are primarily used as residence by the homeowner. In those type of cases, if there's no general contractor involved, then you can't sue because the homeowners are exempt. However, one thing we have seen is that with the rise of investment properties in New York State, and even New York City, people are buying properties and renovating them to use them for verticals or Airbnbs or to flip them. So in those cases, even if it's a single family home, if it's being used for investment, the labor law is now applied. So you can now sue, you can sue under labor law for a commercial owner, or anybody who's basically using a real estate property as an investment.
So we covered a bit of scaffolding and ladders and whatnot. What if someone gets hit by something that falls on them? Can they sue in those cases?
Usually, yes. Usually a falling object is a prima facie violation of a labor law 240 case because labor law requires safe means of moving materials and loads. So, for example, if a load is being lifted and something falls off of the load, it's being hoisted and the hoist breaks or those kind of things, and someone gets hurt, certainly they could sue. If some debris falls off the top of the roof, certainly they could sue. Why? Because the labor law requires safe means like buckets, chutes, and other things to transport debris from one level to another. So basically, things are supposed to be done safely, and where they're not, if something falls and hits somebody, usually there's a violation of the labor law.
And what if the person being injured doesn't have fall protection? Then what?
If a person falls and they don't have fall protection and they're at a height where fall protection was generally required or should have been provided, they have a lawsuit under labor law 240 because, there's 2 violations. There's a violation of not providing proper protection to the person who is being elevated, right? And then there's the secondary risk. In other words, there's a secondary risk of a person falling off of something and you have to also protect against that risk of elevation or that risk of gravity.
Now, what worker rights exist when someone gets hurt during, say, marine construction?
Marine construction is a little bit of a specialized area, which we have experience in, actually. Normally, when a person gets hurt in New York State, they get workers' comp benefits, which are through their employer, and they get their wages and paid in a certain percentage of the wages paid, I should say, and they also get medical benefits. However, when people are working over the water or at the water's edge, New York State workers' comp is actually preempted by the General Maritime Law and the Longshore Harbor Workers Act, or the Longshore Harbor Workers Compensation Act, which is federally run by the Department of Labor and the Office of Workers' Compensation Programs. So the good news is for construction workers who are injured on the water, such as dock builders, bridge workers, pier workers, marina repair people, and those sorts of workers. The good news is for them is the federal Longshore Harbor Workers' Compensation Act actually allows higher percentage of wages for injured employees than does the New York State workers' compensation system. So if you're injured on the water, you actually get more of the salary than you would have gotten had you been injured 20 feet over on the land, or if you were a land-based construction worker. So if you're working on a barge, if you're working on a float deck, or you're working on a pile or sheeting at the water's edge, you're actually going to do better financially than you would have been had you been injured on land. Also, the same labor laws apply. So even though the state workers' compensation laws are preempted by federal law, the General Maritime Law allows concurrent jurisdiction to the state worker protection laws. So you can both collect federal benefits and sue under New York State's protective laws, which are actually more liberal and sui generis than the federal laws are.
So jumping around a little bit, what if someone gets hurt during a collapsed wall during a demolition? As
a result of a wall collapsing during demolition, is entitled to sue under Labor Law 241 sub 6. We talked a little about Labor Law 240. 241 sub 6 of New York's labor law basically codifies the New York Code of Industrial Rules and Regulations and provides causes of action or lets people sue for any violation of the New York Code's rules and regulations. So there's a lot of regulations concerning demolition, how demolition is supposed to be done by hand, how it's supposed to be done mechanically, and all of these are meant to protect the worker who's both involved in the demolition and other workers who are working in the vicinity of where demolition is being done. And one of the big regulations is for the walls to be braced and short so that when they are being demolished, They fall in a certain way not to injure the worker.
And what about suing when there's a trench collapse?
If you were injured in a trench collapse, you have the right to sue. Why? Because the trench is supposed to be properly braced and shored to prevent any type of collapse from occurring. And some of these trenches, for example, if they're in the street, the edge of the street or sidewalk are pavement or cement. So it's very heavy. When these trenches collapse or cave in, the materials that are on top, the heavy materials such as concrete or flag, fall onto the worker. So we've seen some really horrible injuries with trench cave-ins.
So you've set some precedents in your legal activities. There's one with an excavation case, if you can detail that for us.
Sure. So we had one excavation case where a landscaper actually on a construction site was working with an excavation team to dig holes for trees. And there was a lot of motions because the defendants didn't think that the labor, or contended that the labor laws didn't apply to this particular individual. And not only were we able to convince the lower court, the Westchester Supreme Court, that the labor laws applied to this particular individual, it went up on appeal to the Second Appellate Department, and the Appellate Court agreed that certain labor laws applied to this type of situation. And what made this really interesting is somebody who wasn't typically a construction worker, but he was doing work on a construction site. And what the court said was, it took a somewhat of an expansive view of anybody who was doing construction work. And the reason, why should somebody who's digging a trench or an excavation for a pipe 10 feet away from this guy be protected by the labor laws, but this gentleman who's digging a hole for a tree not be protected? So really what they came up with the rule was that anybody who's doing construction, who's doing work on a construction site, even if the work isn't in and of itself considered to generally be construction, where that work is in connection with the construction project, the laws apply. And what also made this interesting is this particular gentleman got struck by an excavator. So we were one of the first, in my case, was one of the first cases where some of the rules to talk about, there's one particular NYCRR regulation which talks about people being within the swing of the radius or the radial swing of a bucket on an excavator while the bucket's in gear. Okay. And generally what it says is a worker isn't supposed to be in an area where they could potentially be struck by the bucket while the bucket is actually, or while the motor for the excavator is actually in gear. And what we were able to establish is that through expert testimony, including someone who taught at the union school for excavation, is that these excavators are hydraulic machines, which means that once they're run by hydraulics. So once someone activates a safety, that takes the motor completely out of gear. And what the operator testified is he pulled the safety, and he got up to look at the hole, and then his leg hit one of the controls. The bucket swung and hit our client, caused very serious injuries. What the courts basically agreed with our argument that I should actually back up. So what actually happened eventually is we went to a jury trial, and the jury found that it was physically impossible for the motor to be engaged if the safety was adequately activated, which means that the operator didn't activate the safety. So the jury found actually that the labor rule was violated because the operator got up and left the seat, which is another violation. The operator is supposed to stay in the seat with their hands at all times on the controls while the engine is engaged. But in this particular case, they found that the operator violated the rules by getting up to look at the hole while the motor or the engine was still engaged, and having just pulled the safety, it would have been completely safe for him to get up. And because he violated the law, our client got hurt. And that was a major victory that was upheld by the appellate courts and basically set a lot of good precedent for other construction workers and people that are doing some of the ancillary work on construction sites. In this particular case, they were doing land clearing and installing new trees, which is part of the overall development of the site.
Yeah, certainly a great legal victory and something for people to keep in mind. Thanks for tuning in to Trial Talk, insights from legal expert Michael Joseph. For more information or to connect with Michael, visit NewYorkTrialLawyers.org.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.